Please be seated. All right, I think we're ready for our third case now, VAVILOVA versus RIMOCZI. I think I just probably butchered that name, but RIMOCZI?
Yes, RIMOCZI.
RIMOCZI.
Good morning, Your Honors. May it please the Court. My name is Susan Erlenbach of the firm Erlenbach Law Offices, and Your Honor, I would like to reserve 5 minutes for rebuttal.
Okay.
With regard to this case, I represent TATIANA VAVILOVA, who's the wife in the case below and the appellant herein. Ms. VAVILOVA is contesting several aspects of Judge Earp's final judgment, including that she was awarded insufficient alimony for an insufficient time, and that she was that the equitable distribution was done incorrectly with regard to the characterization of a pre-dissolution of marriage gift of $7,000 that the court then took as part of the equitable distribution.
Can you explain to me factually what happened at the time that the judge announced his ruling, and then there seemed to be some negotiation and some change in what happened? Can you outline that for us, please?
I'd be happy to, and I think that gets to the heart of my opponent's contention that somehow I was supposed to start objecting to what the judge was saying.
Well, it seemed like there might have been a stipulation.
Yeah, that's what it looks like to me, too.
I would disagree with that, Your Honor, and I can, on my...
Your client said, well, that sounds good, but I want $808 more. I mean, it seemed like, because they went to lump sum money.
I would dispute that. I would dispute that there was any negotiation. What happened was essentially...
They'd have to pay the $7,000 back if that was going to happen eventually. I mean, he treated it as in her column as marital money that she had received.
Exactly, and that decision was already made, and we weren't in a position at that point. We couldn't really say, "Judge, you're wrong."
Right.
Obviously, we believed the judge was wrong, and we argued in motion for rehearing the judge was wrong.
They were trying to figure out a way, or it seemed like collectively, that's where she wouldn't have to bear the burden of that by kind of lumping in, the alimony and some attorney fee stuff, where, she didn't have to pay all that back, and it seemed like she wanted a little bit more money, which they said, okay, we'll pay that.
No. They didn't say that it was okay, and that's where I contend.
The $14,808 or whatever it was.
No, he did not order that. He said no, $14,000.
$14,000. Okay.
And so I would submit that we never conceded that was. First of all, we never conceded that was appropriate to take the $7,000 away.
Okay.
We never conceded that $14,000 was adequate for alimony, and we certainly never conceded that the original ruling was.
Let me ask you this: of the $7,000, wasn't that a factual finding he made? I mean, the judge made a factual finding contrary to, your client's testimony that it was a gift and it had nothing to do with, the divorce, and the fact that he put it on there really didn't. I mean, he found against you on that. Factually.
Even if he did, even if that's the position you want to take, and I understand that, Judge, we have to look further in the case law that talks about dissipation of assets and the case law that talks about equitable distribution, that where you've got an asset that's all gone and it's been used for appropriate purposes, then it's not reasonable to turn around and say, yep, that asset that you spent 2 years ago, that's yours, and basically use that to live on, to pay your attorney's fees, and to take care of everything else.
It seemed like it was half the money that was in the bank account, wasn't it? Is that or something?
Plus 500.
Plus 500, yeah.
Back at the time that the gift was given, there was an asset, and at that point in time, two months before the dissolution was filed. 2 months before the dissolution of file, there was a CD. That wasn't all the money they had. That was a CD, and they even exchanged an email about it, and that was part of the evidence. And he wasn't happy with her idea that she would like to help her son, but they had helped their children. That was part of their marriage. She didn't work. He worked. And that was part of what they'd done. They had adult children from prior marriages. And so he grumbled about it, but he still gave her the money. He still gave her what she asked for, and he knew exactly what she was going to do with it. And so to suggest that somehow...
But that's not what the trial court found. And we're sort of bound by that.
Well, but I think...
If there's evidence to support it, and there was.
Judge, I think, though, where the trial court went wrong is that the trial court said, yes, and that $7,000, ma'am, go ahead and use that to pay your attorney and pay your, and that goes toward your living and so forth. He took away alimony he'd awarded her. He took away any entitlement to attorney's fees, which she was clearly entitled to, and said, so sorry, but you're going to have to somehow recoup that $7,000 that you gave away 2 years ago. I mean, it's just, it's fantasy, it's unreasonable, and it shouldn't be allowed to stand. The courts, there are many cases that I've cited in my brief where assets that are used while the action is pending, or assets that are used other than for misconduct, but they're used up, are not to be charged against one party or the other as part of equitable distribution.
She gave the money to her son to buy
Yes, she gave the money to her son
to buy an apartment.
To buy an apartment in Russia. Yes, sir.
Did he continue? I guess I remember somewhere that he, during the marriage, he gave her an allowance of $400 a month or something.
Right.
He continued to do that, I take it, during this period of time,
during the separation.
Up to the filing of the petition.
Up to the filing of the petition, and then there's a temporary relief order. We did get some temporary alimony from Judge Roberts. And I would point out that essentially the alimony issue, stepping aside from the equitable distribution issue for a moment, but looking at the alimony issue, the court erred in awarding or in imputing income to my client of $1,300 a month. She had no track record whatsoever in the marriage of earning money.
She worked in England before the marriage.
She had worked in England before the marriage. That job she gave up over a year before she came to the United States because the husband wanted her to, because he was petitioning for her fiancé visa, and to do that she had to be in her home country. And so essentially, and what's really important in this situation is to understand that there was no dispute that they both agreed she'd come over here and she would take care of the house and she'd take care of him and the dog. There was never any suggestion that he wanted her to work and that he was pressing her to work. It wasn't until he decided he didn't want the marriage anymore that she was in a position where she had to look for work. And she did. And I would submit to the court that she had made valiant efforts. She had her diploma certified. She'd taken some brush-up courses and done some other things. But she did not have a job. She didn't have an offer of a job. She didn't have a hope for a job. And to this day, she doesn't have a job. And I'd submit to the courts that it's not the idea of, giving her a few $1,000s and sending her on her way is, the husband's left with a house that's paid for, a car that's paid for, health insurance, and all of those things.
That was done before they were married, correct?
Those things were done before they were married, but his income, which he got to continue, he worked continually during the marriage, and he established retirement. He had retirement from the military and now retirement from the Titusville Police Department. And he's in this wonderful situation in excess nearly $5,000 a month of income. She has nothing.
Well, she got some small part of it.
She got I believe it's $266, which was part of his retirement, correct. And so she's basically, and that doesn't even cover.
4-year marriage?
4-year marriage. 4-year marriage?
Not that you have 4 minutes.
I'm sorry. I thought you said I had 4 minutes. It was, at the time of filing, it was 4 years and several months, and then by the time of the dissolution of marriage, of course, they'd been married in excess of 5 years.
Let me go back to the issue that I'm still concerned with, this whole issue of what happened at the end, because you said, well, the judge already made this ruling.
Correct.
And then these other things happened.
Right.
Well, normally if the judge makes a ruling and you're not happy with it, your options are either to live with it or to go appeal it. I don't know that your option is to negotiate something premised on that ruling and still preserve your right to appeal that ruling.
And Your Honor, I would agree if Mr. Brewer and I had said, Judge, let's take a break so we can go back here in the hallway and try to work something out in light of your ruling. I would say that you would probably be right, and with all due respect, that you would be right in that circumstance. That's not what happened. And I maybe grew up a little differently in terms of the respect I would show to a speaking judge. I'm not going to argue with a judge during a ruling. That's not the way I've been trained.
Right.
And in my, with all due respect to Mr. Brewer, he's been around a little longer than me, I feel like to some extent he did that. Well, wait a minute, Judge, do you really mean 1,500? Don't you mean minus this? And what about this? And what about that? And that's just, I've always been taught that's not really, again, with all due respect, that's not really the way we do it. We wait, we take the ruling, we file a motion for rehearing. At no point in time was it any kind of negotiation where I could say to my client, okay, this is what they're offering, what do you think? And sit and talk. I mean, I would say the most, and I would concede this point to Mr. Brewer, that when it came to, do you want the boat or do you want the timeshare? Basically, I'm whispering her, do you want the boat or do you want the timeshare? And she says the timeshare. I would say we conceded that. I mean, there's no getting around that. We get the timeshare, whatever, for whatever it's worth. But I would submit that that's not the same thing. That's not what happened in terms of there was no knowledgeable or appropriate negotiation that took place. It was basically they're trying, and you can even see at one point in the transcript, I say to the court, look, I'm getting really depressed. How is she supposed to live? I mean, it's clear that we weren't saying, oh yeah, this is a great deal, we'll take it. That's not at all what occurred. And, the fact that the judge changed his mind midway from, okay, instead of giving her this payment to, we're going to take away this and take away that and give it to her in a lump sum.
How do you explain this exchange? Counsel for the wife, Mr. Brewer, my client is asking if he would pay the $14,808 in lump sum, and then she'll be responsible for her attorney's fees, $14,808 in lump sum. Counsel for the husband, $14,808, counsel for wife, which is the 12 times, counsel for husband. So we're saying $808 more than what the court, she wants another $800 over what I just said anyway. Counsel for the wife, that's what she said. The court, okay, then it's going to be a lump sum alimony of $14,000, 10 days. That sounds to me like everybody was involved in the final formulation of this judgment. I mean, it sounds like you were deeply involved as well. What
I would submit, Your Honor, is that at that point in time, seeing the way the ball was rolling, we did say that one thing, but the judge rejected it, so it's not as though we had the judge just basically overlooked it. It's like, no, not going to do that.
The reason I read that was not just to suggest that it was effective. The reason I read it is because you have been taking the position that you didn't have any alternative but to sit quietly by while he ruled out loud. And it's quite clear that you were involved in it.
It's clear that I made that statement, Your Honor, but what I would submit is that at that point in time, it wouldn't have been appropriate for me to say, but wait a minute, we want the $22,000 or whatever, because that's what she's really entitled to.
Talk that way about the timeshare versus boat issue. I mean, you were directly involved in that as the judge was concluding his comments.
I understand, Your Honor. I understand what the court is saying, but I would still submit that we did not, it wasn't a negotiation in terms of any kind of ability to, the dice had already been thrown. I mean, we couldn't pick up the dice and throw them again.
We're talking about preservation.
Yeah, right.
I'm sorry?
We're talking about preservation of issues.
Okay.
And you have an obligation to point out to the trial judge where he's wrong.
And we did that in our motion for rehearing, and that's the appropriate place to do it, in my opinion, based on my understand, I would submit, based on my understanding of appropriate trial etiquette, that's the appropriate place to preserve your issues, is on motion for rehearing. We filed a comprehensive motion for rehearing, Your Honor, in which we brought up all of these issues. The only issue that Mr. Brewer is correct that I didn't bring up is the issue of the diamond ring and the diamond bracelet. We didn't bring the bridal set and the diamond bracelet. We didn't bring that up. All of the other issues.
Were they in any of the financial affidavits?
They were listed on my client's financial affidavit. I believe the wedding set was listed on my client's financial affidavit. But if I can, I'll get into that for just a minute. That's really not the most important thing, but in my opinion, but basically the judge ruled early on, she gets all the jewelry. She gets all her jewelry. And that was part of her jewelry. And at the end, Mr. Brewer took the position in the final judgment, no, it wasn't all her jewelry. And I in error, didn't make a motion for rehearing on that issue. However, I would still submit that it could be an enforcement issue that we could get into, that all her jewelry should include the bridal set and the bracelet. It was all her jewelry she was awarded. But, Your Honor, regarding the motion for rehearing, a motion for rehearing is the appropriate place to preserve error. I've never seen, and I looked at the cases about preservation of error and so forth, and invited error. I've never seen a situation where during the course of an argument or during the course of a ruling, there's a requirement of an objection. Okay, thank you, Your Honor, and I will wait. Thank you.
Thank you. Please the court. I'm Steve Brewer. I represent ZSOLT RIMOCZI in this particular matter, the appellee. I would like to address one of the issues you raised, Judge Jacobus, that is with regard to the $7,000. That was not a marital asset. That was his non-marital asset that he had in a separate account from his...
It represented about half of the money in the joint account, is that right?
It was never in a joint account.
No, I understand that.
Right.
But was there like $14,000 in the account at that time?
I believe so.
And he just took it out and gave her what I thought was like what would equal to what was half of that account.
It was never in a joint. It was never in joint funds, or it would have been declared. It would have been considered a gift and declared by the judge to be a marital asset. And it specifically found that it's a non-marital asset and that it was an advance on an equitable distribution to be made.
I understand that.
Right. And the other issue that Ms. Erlenbach raised is about being expended. I believe all of those cases relate to expending it on necessities. If you need food and clothing during the pendency of the action and you use a marital asset that you had on the date of the filing, then that can be excluded from this. This giving that $7,000 to her son certainly wouldn't qualify for that. We get into the discussion that everyone's raised with regard to the negotiations. What had happened in the transcript, I think is fairly clear, is the judge made his rulings. I think he made very appropriate rulings with regard to alimony. I thought they were too much, but I think under the circumstances they were very thought out in trying to get Ms. VAVILOVA into a position of being self-supporting. He gave her $2,000 immediately to move out of the house, get her first and last, and then he gave her an amount of money per month that amounted to $1,500, plus the $1,300 that he imputed to her that she could find a job immediately and do. That gave her $2,800 a month to live on under the judge's findings. If you take away the $1,500 from my client's income of $4,500 a month, he's left with $3,000 a month to live on. So the judge almost equalized their incomes in his findings, with her having $2,800 gross, him having $3,000 gross. So I think the ruling with regard to the alimony and the bridge the gap alimony was very appropriate. I think it's what was bridge the gap's intended for, and that's why it was created, to give her a year's period of time to transition. The court will recall, I'm starting talking real fast. It's a bad thing to do. I'll slow down just a little bit.
We're going to cut your time in half if you keep
Judge
going.
Monaco wants you to talk fast.
Oh, he does? Well, that's why I figured the temperature was the way it is, so we would be talking a little faster. But, you know, we get into the discussion of her ability to do work. The judge put a scale of what she could go get a job that day to do to make the $15,000 that he imputed, or $27,000. There were jobs available. Not to mention that she has and had a temporary teaching certificate, which would allow her to teach in any school in the state of Florida, Brevard County, and make $35,000 to $36,000 a year.
There were no jobs in Brevard County, correct? I mean,
there was one job available. She had testified that she had applied for a couple of the ESOL jobs, which has to do with the language skills, right, which she is definitely qualified to do. Even at what he imputed to her, that's just about $10 a month above minimum wage of $7.25 an hour on a full-time basis. Walmart pays more than that. She could have certainly gone and made that at a Walmart at any particular time, and there was testimony that those jobs were readily available to her at that time. I get back to the negotiations, everybody call it. I think it was, in fact, some negotiations after the judge had made his initial ruling. Mrs. Erlenbach's client could have certainly said, and that's why I believe you're right, they can't come in here and argue the deal, the lump sum money they take. They can argue the amount of alimony and the length of time, I believe, but I don't think they can argue the deal that they made, because they could have certainly said, Judge, no, we don't want the lump sum. We'll take your award of $2,000 immediately and the $1,200 and whatever dollars over the next year and done it that way. So I don't see how they can raise that particular point. The alimony that was awarded would seem more than appropriate under the circumstances of a 4-year marriage and allowing her to transition to being able to be self-supporting. Let me see if I've covered. I think I've covered the points that she's raised, Judge, and in view of the temperature and the air conditioning, I'll let my brief stand for the rest of that. Thank you.
Okay, Counsel. Or maybe we'll keep the heat up all the time.
You got heat lamps up in the ceiling.
Yeah.
Judges, I do want to mention this because I do think it's a very important point, that the trial judge apparently had a misconception about contributions to the marriage. And I think that the case law is clear that where the judge appears to have a misunderstanding about the way the law works, that is a basis for reversal, and particularly when it comes to alimony. In this case, the judge suggested that my client's contributions to the marriage didn't enhance any marital asset or weren't valuable in a monetary sense, and therefore they didn't count in terms of her entitlement to alimony. And I would submit that that's contrary to the case law, as well as, and I would cite the court to the Green case that was decided in this court in terms of where the court had a misconception, the trial court had a misconception that somehow the wife had to be disabled from being able to work in her prior profession, that therefore that affected her entitlement to alimony, where the court said that that's wrong. That's wrong law, and therefore it's reversible. There's clear misconception is grounds for reversal. And that Green case, I'm sorry, is the Green versus Green, decided in 2005 before this court. And I apologize, I don't have the Southern Second site, but it's in my brief. Your Honor, I think that's very important because it shows, again, a misconception about what matters in alimony. What matters in alimony, the judge also had a misconception because my client arrived here with little in material goods, and she enjoyed a comfortable, nice lifestyle, European travel and lots of jewelry gifts and the ability to shop and buy things and travel to New York and so forth, that was actually against her in this case, that she should be lucky, she should consider herself lucky. I would submit to the court that that's, again, a misconception. Actually, all that means is that she's now in a terrible position because she no longer has the support of her husband. She doesn't have anything in terms of premarital wealth to fall back on. She has very little in regard to material goods to fall back on. She left her job more than a year and a half before. She didn't work throughout the marriage, and her bachelor's degree that they're talking about is from 1982. So again, she's like Mrs. Green in this case, who had not worked during the marriage because the parties agreed she shouldn't work during the marriage. In this particular case, there were children. In my case, there weren't children, there was a dog. But in any event, the parties agreed she should stay home, she should keep the house, she should have lunch ready when he got home from work, she should entertain his friends when he brought his friends over. That was her job. And simply because her doing the wallpapering and putting down the patio stones didn't add value to the house, or it wasn't a significant monetary result, that doesn't end the question. That doesn't take away her right to alimony. I would submit.
How do you
that's
respond to the argument that when you include imputed income, their incomes are virtually the same after this alimony award?
Well, my response is it was error to impute income. It was error to impute income.
Well, what if we don't agree with you and we decide the imputation is fine? Then do you think the alimony award was appropriate?
If you think the imputation is fine, was the alimony award appropriate? No, because it wasn't for a sufficient duration. She had no job. She had no hope, no prospects of a job. She had applications out all over, but she had no prospect of a job. And I know there's another case I cited in my brief that says, it's going to take some time, typically. And
Or wasn't there some testimony before the trial judge that there were jobs available immediately?
there were, actually, the only testimony about that was that my client had heard about some jobs coming up
Well,
through the
there was-
ESOL program, that she'd applied for them, but the jobs that Mr. Brewer's expert testified about were clerical jobs, and that expert had no knowledge whatsoever about my client's clerical skills. She had no knowledge of her typing speed. She had no knowledge of her computer usage. She had no knowledge whatsoever, and could present no testimony that would suggest that my client was qualified for any of those jobs that were available. They were clerical jobs and jobs as teaching assistants and things like that. She had no knowledge about my client's particular skill set other than her language abilities. And I see my time is up, and we appreciate very much your consideration.
Thank you, counsel.